So nothing here constitutes legal advice. Just want to get that clear. A disclaimer from the beginning. This is simply for informational purposes. So what I'm going to do here is I'm going to run down this affidavit of sovereignty, and I'm going to go over the codes, etc., that back up what it is that's being said here, right? I'm not going to go too far into detail into the codes on this video, but I'm going to make another video explaining the code in a little more depth in order for you to get a good understanding of what this is really saying here. Okay, so what this is the Affidavit of Sovereignty. Equality under the law is paramount and mandatory by law. I, your name, a titled sovereign, hereby declare that I am competent to handle and manage all my affairs. All other entities are incompetent to manage my affairs and are hereby fired. A sovereign cannot be tried in their own court. Consistent with the universal, eternal tradition of natural law, unless I have harmed or violated someone or their property, I have committed no crime. Therefore, I cannot be subject to penalty. Thus, be it known in the nature of UCC 1-308 that I reserve my natural common law referenced right not to be compelled to perform in or under any contract that was not entered into in good faith, knowingly, voluntarily, and intentionally. I do not consent to accept the liability associated with any compelled and or forced pretend benefit in order to attempt to implement a subsequent action moving forward in order to execute on an imaginary or hidden unrevealed contract or some supposed commercial agreement under admiralty. I do not consent to accept, nor will I ever accept, the liability for any ens legis in question unless expressed accordingly in a written wet ink signed contract to be produced by anyone making any claim at any point ever. Nor should I be expected to perform according to any stipulations contained in any fraudulently obtained contracts to include but not limited to hidden or unrevealed contracts that supposedly created the surprise obligation to perform for persons of subject status. Nor will I entertain the expectations and stipulations contained in any fraudulent third-party unlawfully obtained contracts. These are absolutely inapplicable to myself, have zero effect, and are hereby null and void, effective immediately, to extend to the day of creation, and such status will be sustained moving forward regarding, but not limited to, any fraudulent contracts and documentations forever. Any acts of aggression, any form of harassment toward myself, my property, and or my family members, to include but not limited to threatening letters, demanding anything, unlawful detainment, and the like, will be taken as an act of raw, we'll call that, by any insubordinate trespassers of the foreign United States military occupying party, and will be referred to the international courts for disciplinary action. Any agent should be in full uniform, as well as full credentials displayed as well, a business card, hazard bond in hand, and prepared to conduct business accompanied by their shift supervisor and or commanding officer on duty. If at any point my commercial conduit partook in any of the supposed benefits associated with any hidden contracts, it would have been under duress, as well as a lack of awareness of another option being available. Receiving a benefit cannot constitute acceptance of any unconscionable contracts. Close examination would reveal many missing elements necessary in order to qualify as an enforceable good faith contracts in accordance with the universally recognized Uniform Commercial Code. Complete lack of full disclosure of all underlying facts, lacking voluntary consent, lacking a straightforward, valid offer, consideration and acceptance, misrepresentation, as well as threat, duress, and coercion in order to secure said contracts. There has been absolutely no meeting of the minds, and therefore there exists no elements of a valid contract that any court of good faith, in accordance with the clean hands doctrine, could ever rule in favor of, due to the exhibition of a complete lack of equal consideration. Any and all contracts are nullified, void, ab initio, immediately. The fact that compulsory action was taken, resulting in a subsequent birth certificate being granted to myself by a local hospital, government agency, when I was birthed into this realm, has no bearing and cannot be construed as the forfeiture of my sovereign birthright. Per the Baby Act, no man or woman is liable to be compelled to perform under any contract entered into or created during infancy or a minor. Status high or low cannot be assigned to another living soul through a piece of paper, especially from public servants, or without the consent of the referenced individual recipient. Therefore, such a paper only serves as hearsay that courts always seem to address as a fact. It serves solely as the date and place of birth info only. It cannot dictate anything regarding jurisdiction. It cannot address property ownership. It cannot be an indication of rights or subject status or lack thereof. The only contracts that have any legal bearing in reference to my status in society are those that were signed with wet ink in accordance with the Uniform Commercial Code, published and established elements necessary to be considered an enforceable contract. As a fully informed adult, free from misrepresentation, drugs, in good faith, absent threat, duress, or coercion. My birth certificate, bond, and warehouse receipts have been redeemed in the UCC-1, signed on and received by and recorded by State Department of the Secretary of State on the filing number, and all titles in question have been authenticated, claimed, and accepted for value on a UCC-3 on top of a allodial title. Therefore, no unexpressed, unapproved parties can or will ever hold any claim to either my commercial conduit nor to my physical, tangible, natural body. The use of an identification number from any government agency, 50 U.S.C. Chapter 53, Trading with the Enemies Act. The number normally assigned to persons of subject status, I have a priority claim to, as I am the source of which its creation is based on, and may use as a beneficiary, as I am the only one funding the account. Also, because of the extreme inconvenience of operating without such account information in today's commercial venues, be it known to all that this does not make me a surety for the fictional national debt. This cannot make me a subject of the United States. The suspended gold clause essentially pushes everyone into the fiat currency system. As well, it is demanded by many government agencies and businesses to access the estate and essentially subsequently fund the various public establishments, which is not a problem if obtained in good faith and not in the manner I see it happening. Let it be known that I may use the numbers assigned for the purposes of information only and to streamline any interactions in the public. If there is any hidden contract associated with my signature on a bank card, this does not suffice to serve as evidence of an acceptance of any hidden contracts or any obligation to perform. I may also use this to fund projects that are in line with the spirit of being truly in line with the spirit of the American people. As well, any agency directly related. This also cannot be construed as myself accepting a demotion to a subject of the corporate structure of the United States without America. The use of a bank account with my signature on the bank card, the signature is solely for the purpose of verifying identity and cannot be compelled to perform based on an unrevealed, hidden, intangible contract. Also, my use of the bank account, therefore, is due to a shortage of banks unassociated with the privately owned Federal Reserve System, FDIC. It is virtually impossible to locate such facilities operating independently, as well as various governmental agencies obstructing and or making it difficult for Americans to issue their own currency, in direct violation of constitutional law, as well as HJR 192, Public Law 73-10. Due to the current financial climate and lawful money not as readily accepted as legal tender, courts under a Chapter 11 bankruptcy reorganization move forward with third-party debt collection actions by force and do demand a certain species of currency, choosing not to honor the coin of the realm, which includes but not limited to promissory notes and bill of exchange, subsequently dishonoring negotiable instruments without opportunity to cure or notice of defect, followed by demands for Federal Reserve notes or US dollars, etc. For these reasons, I may use this method, as well as others, to set off any and all public obligations regarding monies. Therefore, if I do use Federal Reserve notes or the like, this will never be construed as placing myself into the subject of a public servant status. Past tax returns filed in the past. 26 USC Clause 7343, definition of the term person. The term person as used in this chapter includes an officer or employee of a corporation, or a member or employee of a partnership, who as such officer, employee, or member is under a duty to perform the act in respect of which the violation occurs. Also, according to legal definitions of persons: 1. A human being. 2. A corporation treated as having the rights and obligations of a person. Counties and cities can be treated as a person in the same manner as a corporation. However, corporations, counties, and cities cannot have the emotions of humans, such as malice, and therefore are not liable for punitive damages unless there is a statute authorizing the award of punitive damages. See also Corporation Party. August 16, 1954, Chapter 736, 68A, Statute 872. Furthermore, any tax returns or compulsory payments made to any public corporation in the past were a mistake and have been rectified through pertinent agencies, and my ignorance of the actual nature of such benefits and the skewed information regarding details about such organizations may have led to contracts commencing, which may have led to the supposed adhesion and implied contracts as well. Let it be known, any hidden standing, obligatory, unconscionable contracts that anyone may feel exist or ever possibly could exist are null and void ab initio. As well, I am aware of the fact that there is not and never was any federal law, nor through the IRS manual, compelling a private personal labor tax. This is the Britannica definition of slavery: the condition in which one human being was owned by another. A slave was considered by law as property or chattel, and was deprived of most of the rights ordinarily held by free persons. I am absolutely obliged to terminate any and all unclean, unconscionable contracts, whether entered into voluntarily or not, as of this day, ab initio. Therefore, there exists no valid, good faith, verifiable, enforceable contract. There exists no standing, nor does there exist any standing obligation from myself to perform. There exists no foundation or authority from which any entity can move forward with any public claims or otherwise upon myself or my trademarked commercial conduit, unless otherwise stated in an express, written, and signed wet ink contract, such as my fee schedule, embodying full disclosure, clearly written, spelled out in common English, using clear, precise language, containing the full and complete extent of obligations of all parties involved with said contract. Any standing unexpressed contracts are hereby terminated. See attached fee schedule. The use of a driver's license. Public agencies do not make public laws, bylaws, codes, or statutes that are applicable in the private. Short of operating in commerce, you are out of your bounds. The use of any license in general is for the sole purpose of operating in commerce or doing something that would otherwise be illegal, such as a license to practice law. The practice of law cannot be licensed by any state per Schwar versus Board of 430 Examiners, United States Report 353, U.S. pages 238 to 239. I am not sure which of these categories that would fall under, but I have yet to see a license to practice law. As a free sovereign, there cannot exist a legal or lawful requirement for myself to obtain a driver's license, as it is solely for the purpose of operating in interstate commerce. A private man cannot be subordinate to a public servant, and I will not. It is impossible according to the current government structure. However, we may be cordial in the course of business should this take place. I am cognizant of the fact that many of your agents may be mentally disabled and or impaired by their limited understanding and or negligent willful ignorance of law. I command that you place my affidavit and declaration on the record for your enjoyment in a database easily accessible for all public servants under our control. In order to avoid any confusion, as I can imagine they would be extremely confused regarding anything that has to do with their own signed oath of office, bonds, laws, or contracts. Furthermore, you will take notice of my position as for the reasons why I may or may not be in possession of a commercial driver's license at any point. The former nor the latter will be construed as myself accepting any hidden contract. According to law, my automobiles do not fit the description or legal federal definition of 18 U.S.C. motor vehicle. The term motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highways, in transportation of passengers and property or cargo. This is not the case, as I myself have never used the roads in a fashion consistent with anything that can be construed as sufficient evidence to categorize myself as a commercial driver as much as a traveler. I may have possibly registered my vehicles with the state prior to claiming my plates as private property, with the signed recipients directed to record my state as such. Notice has been served and outlined in multiple unrebutted affidavits, administratively perfected, defaulted, post-certified constitutional challenges, affidavit, estoppel contracts held by myself and various individual state agents and officials. I cannot be held responsible for an officer's negligence or failure to act on their duty to honor my verifiable multiple postmaster certified notices. Declaration of citizenship. Regarding any documentation that may have potentially been signed to which I may have answered yes to the question, are you a U.S. citizen, does not subtract from the sum of all that I am, and cannot compromise my sovereignty. I am not, nor will I ever be obligated to perform because of the existence of a piece of plastic or paper that bears writing that resembles my name, and lettering that resembles English. Any hidden or supposed contracts associated with inscriptions on a piece of plastic would be a fantastic hallucination and are null and void ab initio. Lack of complete and full disclosure does necessarily void any and all actions associated with any contract or title in question, in the case that it is thought or found to be fraudulent in nature. These violations, aside from the many, will nullify any and all potentiality of future actions and attempts to compel performance from myself by anyone at all, ever. Especially absent a consensual contract, I am neutral. My only allegiance can only lay with, and will only ever be with, the eternal creator, and not with any earthly government, for the record. Full stop. Past voter registration. Regarding participation in the voting system, no obligation to perform in any manner was ever expressly agreed to in writing as a requisite stipulation when, if I have ever partook in the voting system process. Any such registration on my conduit's behalf cannot be construed as evidence of my obligation to perform. Likewise, I have never and will never willfully grant jurisdiction over myself or my property to any political office or corporation. It is my sovereign right to vote on elections, as well as any issues that can or will directly affect myself and my family, but not limited to such topics. My conduit's registration does not signify an acceptance of a lesser status. It also most certainly will not be construed as consenting to an overlord. Actually, to the contrary, many are redundant. I may or may not have used the voting process in the past. However, should I ever decide to do so again publicly, I will do so under the strict stipulation of reservation of rights, Uniform Commercial Code 1-308, as always, in order to ensure that the will and the wishes of the sovereign people of this beautiful country are always being met and granted us beneficiaries. Marriage licenses. The acquisition of a marriage license is now being revealed as having been necessary only for slaves. A license may have been mistakenly obtained in the past, possibly absent my reservation of rights outlined in such documentation. Such a thing will not be construed as acceptance of a lesser or subject status. Likewise, I will accept no legal ramifications or bearing whatsoever in any case or action affecting my conduit status or the final outcome of any given situation because of the assumed or presumed existence of any hidden implied or adhesion contracts and the imaginary effect thereof. This is true because any such change in status at all ever may only have come about through fraudulent criminal activity and misleading information, most likely in the form of an oppositional, constitutionally void, and nullified commercial state code or statute, cannot be construed as an acceptance of a demotion and is null and void. Children in public school. The attendance of my property, children in public schools or private schools, does not create any legal jurisdiction as a free benefit, as paying for the service was never presented as a viable alternative nor requested. Neither voluntary nor compulsory attendance will place obligations on myself nor my family, especially absent a express wet ink signed good faith contract expressing in the literature showing an agreement to become a subject in exchange for the purported benefit of such an activity. If the participation of my property attended public schools has ever been sufficient for you to concoct an idea such as subjectivity upon any applicant, let it be known any and all hidden contracts associated with the foregoing are absolutely nullified and void on their fraudulent face, effective immediately, now and forever. I take exception to any public servant believing they are in a position to make such a determination or claim, or exerting borrowed power and acting well outside of their limited privilege of delegated authority. Not a single part of foregoing will constitute a proof of my conduit being a U.S. citizenship per good faith doctrine. Use of semantics. I am aware of the fact that there exist law dictionaries as well as commonly used dictionaries containing words that are spelled the same. However, upon closer examination, you will notice that the same words have different meanings in different books. I would like to assume every single court mistakenly moves forward with the actions and never publicly declares the book from which the contracts and language being used therein are actually derived from. Neither the cause and nature of any action, it seems that the literal rules outlined below are not being applied. Outlined here. The starting point for the courts in interpreting a statute is the literal rule. The literal rule is where the courts simply look at the words of the statute and apply them as they are written, giving them their ordinary and natural meaning. It does not seem to me that due to the commercial administrative nature of the courts, that words used therein are twisted in order to try and make private activity appear as presumed commercial taxable activity, in order to gain jurisdiction and exert a commercial jurisdiction in the private. Commerce is the extent of the boundaries of their statutory jurisdiction, a state creature. It also seems that there has been reckless misuse of limited delegated authority derived from trusting citizens, and may go as far as to establish a business to resemble a court of the people, and will trick people into tacitly consenting by altering definitions. I would like to verify if this isn't the case. This is an extremely dishonest practice and has cost many people their freedom and lives, due to the fact that litigation in court is essentially a linguistics, gymnastic, acrobatic challenge. I will not engage in public controversy for all of the aforementioned reasons. I am able to respond privately, however necessary, to any honorable presentments or offers, as my goal is to remain in honor. Be it known, any assumptions or presumptions of a lesser status end here. There will be no mistaken creation or commencement or words spoken by myself that can ever be construed as an acceptance of a lesser status. Be it known to all that any potential, voluntary or forced appearances, physical or administrative, and proceedings, as well as any communications therein, verbal or otherwise, will be solely under the use of the common usage of the English language as outlined in Webster's dictionary, as well as other common dictionaries. In a court of record, consisting of only first-hand breathing, tangible witnesses associated with the claim in question, be in possession of the original negotiable charging instrument for my consideration, with the ability to stand and speak in order to be questioned in court. Finally, swearing on the Bible to first-hand knowledge to any and all facts. This will be done via sworn affidavits under the penalty of perjury, as well as proof of claim and proof of service with every presentment, as well as a declaration of the cause and nature of bill of particulars, as well as any offer or presentment. Furthermore, this affidavit is noticed that any violation of my rights, freedom, or destructive tampering or trespass of any of my property, to include but not limited to my family, by the U.S. government or any subordinate agency thereof, would be illegal and unlawful encroachment, an international matter, as well as breach of trust, fraud, and treason, to say the least. This is all outside of the scope or bounds of your extremely limited privilege of delegated authority as a public servant. My understanding of what purports to be the extent of the U.S. federal government is outlined and defined below. Article 1, Section A, Clause 1. The Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States. Article 1, Section 8, Clause 17 of the U.S. Constitution quoted as follows. The Congress shall have the power to exercise exclusive legislation in all cases whatsoever over such a district not exceeding 10 square miles, as may be cession of the particular states and the acceptance of Congress, become the seat of government of the United States, District of Columbia, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings, and to make all laws which shall be necessary and proper for carrying into the execution of foreign powers. The Congress shall have the power to dispose of and make all needful rule and regulation respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States or any particular state. Any agency created under Congress cannot have more powers than which it was created. Congress has only authority over commerce, so every agency under it must follow suit. The United States is a foreign corporation with respect to a state. Volume 20, Corpus Juris Secundum. Therefore, no hidden or implied contracts, aside from any expressly stated consent, were given in good faith. No commercial federal law applies to myself, as I am neither a resident nor am I employed by any corporations that can be construed as receiving a free benefit. Any federal territory of the United States, therefore, no federal laws can have lawful authority over me. Furthermore, my participation and use of the United States Postal Service to receive mail is due to threat, duress, and coercion per federal law, which requires that this service must be used rather than any other comparable private delivery service in order to signify proof of service of any particular parcel of which their services are being contracted. As well as the receipt of mail addressed with two-letter capitalized federal zone abbreviations or numeric federal zone designations such as zip codes do not place me in any federal zone nor any federal jurisdiction. It is virtually impossible to send anything using general delivery privately or complete the transaction any other way aside from commercial. Per 30-day limit on general delivery, it is difficult to obtain perpetual general service. Thus, be it known to all in accordance with UCC 1-308 that I reserve my natural common law right not to be compelled to perform under any adhesion contract, as it cannot exist absent good faith, with obvious and equal consideration, as well as having been voluntarily, willingly been entered into. I do not consent, nor do I accept the liability associated with compelled performance for a benefit. I do not consent, nor do I qualify for the receipt of any free benefits from any public agency, nor would I accept. Therefore, that concept is literally impossible. I emphatically refuse to be included in any federal zone. Furthermore, I hereby revoke, rescind, and make void ab initio all powers of attorney, in fact or otherwise, implied in law or otherwise, signed by myself or anyone else as it pertains to my birth certificate and or any other licenses, titles, or certificates issued by any and all government or quasi-government entities. Due to the use of various seemingly fraudulent elements by many agencies to attempt to deprive me of my sovereign heritage and or property, I hereby waive, cancel, repudiate, and refuse to knowingly accept any alleged benefit or gratuity associated with any of the aforementioned licenses, numbers, or certificates, permits. I do hereby revoke and rescind all power of attorney, in fact or otherwise, signed by me or otherwise, implied in law or otherwise, with or without my consent or knowledge, as it pertains to any and all property, real or private, corporal or incorporeal, obtained in the past, present, future. I am the sole legal and ultimate lawful owner. I am the possessor of all allodial title to any and all titles in question forever. Moreover, any and all such associated property, including but not limited to my children and my physical tangible body, are all under no obligation to perform whatsoever. I affirm that all the foregoing is true and correct. I affirm that I am of lawful age and I am competent to create this affidavit. I hereby affix my signature to the affirmations in this entire document with explicit reservation of all my unalienable rights and my specific common law rights, to include not to be bound by any contract or obligation which I have entered into knowingly, willingly, voluntarily, and without misrepresentation, duress, or coercion. The use of the notary below is for identification, and such use does not grant any jurisdiction to anyone. Here then we have the date. It says December 2021. You can fill in the date there. Further affiant saith not. Subscribed and sworn without prejudice. UCC 1-308, UCC 103.6, UCC 1-301, UCC 1-107. This document is true to the best of my knowledge. We have the Commonwealth of Puerto Rico, Municipality of, affidavit number, that's for the notary. I have set my hand and seal of this office on this day, also for the notary. And then below we have John Doe, registered owner of, the all capital name, corporation sole, DBA, John Doe, care of 21 Lovers Lane, and we're from outer space. And so we have the state here and the republic, and it's going to be near the federal zones because it doesn't include the federal zones. Those are overlaid. And then this is to the public servant of the office of multifaceted nonsense, which I think applies to mostly all of these. And then we have 143 Wizard of Oz Drive, city of, state, and zip code. And so I'm going to follow up with this video with another one. This is going to be a little more in depth as to the definitions and a little more information into what the codes mean and how they actually apply here, just for further reference.